Okay, Ms. Potter, would you like to address the court? Please go to the podium and you may remove your mask.
Thank you. To the family of Daunte Wright, I am so sorry that I brought the death of your father.
Okay, Ms. Potter, my court reporter can't hear you, so...
Thank you. To the family of Daunte Wright, I am so sorry that I brought the death of your son, father, brother, uncle, grandson, nephew, and the rest of your family to your home. Katie, I understand a mother's love, and I am sorry I broke your heart. My heart is broken for all of you. Earlier, when you said that I didn't look at you during the trial, I don't believe I had a right to. I didn't even have a right to be in the same room with you. I am so sorry that I hurt you so badly. My heart is broken and devastated for all of you. I pray for Daunte and all of you many, many times a day. He is not more than one thought away from my heart, and I have no right for that, for him to be in my heart. I do pray that one day you can find forgiveness, only because hatred is so destructive to all of us. And that I pray peace will always be with you and your family. Again, I am so sorry. And to the community of Brooklyn Center, I do owe you an apology too. I loved working for you. And I am sorry what has happened to our community since the death of Daunte. The men and women who work for you still are good, honorable people and will work hard for you. Thank you, Your Honor.
Thank you, Ms. Potter. Okay, this is one of the saddest cases I've had on my 20 years on the bench. On the one hand, a young man was killed, and on the other, a respected 26-year veteran police officer made a tragic error by pulling her handgun instead of her taser. Thank you to everyone who spoke. I have been profoundly moved by the comments of the Wright family. Daunte was very loved. His son has lost a father. And Mr. and Mrs. Wright, I cannot begin to understand the grief of losing a child. I'm so sorry for your loss. Kimberly Potter honorably served her community for 26 years as a police officer. She was a respected officer and consistently went over and above the call of duty. She's a wife, a mother, an aunt, a granddaughter, a colleague, and a friend to many. In addition to the letters that were forwarded to me by Mr. Engh, I received hundreds and hundreds of letters in her support from colleagues, family, friends, acquaintances, community leaders and members, and even strangers. I read them all. They paint a portrait of a woman who touched a lot of people in a good way. I want to talk briefly about the aggravating factors that were brought up in this case. As I mentioned before, the state initially took the position Ms. Potter should receive a sentence above the guidelines and filed a brief in support of two aggravating factors under Blakely. All parties agreed that I would determine whether aggravating factors existed to justify a harsher sentence than that set forth in the guidelines. I feel compelled to address the grounds for that request because they were made public, and I think it is important to note they were not proven in this case. The state did not meet its burden of proof on the first factor. It is based on defendant causing a greater than normal danger to the passenger in the car and two other officers when she fired. But the shot only hit Daunte Wright. The passenger and the officers were not injured by that shot. The cases cited by the state in its brief did not support its position. In fact, they illustrate why this case does not involve a greater than normal danger to others. In the Fleming case, he fired a gun 6 times in a park filled with children. In State v. Omaha, defendant fired numerous shots into 2 apartment buildings. There is no comparison here. The state also did not meet its burden of proof on the second Blakely factor. Contrary to the state's claims, Kimberly Potter did not abuse her position of authority. In fact, it is undisputed Ms. Potter or Officer Potter was in the line of duty and doing her job in attempting to lawfully arrest Daunte Wright on the warrant when she mistook her gun for her taser. What's more, she drew her taser legitimately to protect a fellow officer on the other side of the vehicle who could have been dragged and seriously injured if the car were to speed away. Officer Potter's conduct clearly was not significantly more serious than that typically involved in the commission of the crime in question, justifying an upward departure. Turning to defendant's request for a dispositional departure, there is no question that Ms. Potter is extremely remorseful. She showed that today. She showed that when it happened. It is also beyond dispute that she is particularly amenable to probation. But the court retains the discretion to make departure decisions independently. The court is not required to depart even where mitigating factors are present, and that's set forth in State v. Birch, 689 Northwest 2nd, 276, affirmed by the Supreme Court, 707 Northwest 2nd, 660. This has been an extremely difficult decision. In making my decision, I look to the purposes of incarceration. There are 4: retribution, incapacitation, deterrence, and rehabilitation. 3 of the 4 would not be served in this case. Incapacitation refers to the physical removal of a convicted person to prevent them from committing future crimes. That is not an issue in this case. Kimberly Potter does not present a danger of future crimes, obviously. Deterrence refers to the prevention of future crime and the idea that those who have committed crimes will be discouraged from reoffending after experiencing punishment. That purpose would not be served here. Rehabilitation is also not a purpose that would justify incarceration in this case. Ms. Potter does not require rehabilitation to become a law-abiding citizen. Retribution, or serving time as a way for a convicted person to pay for the harm inflicted on a victim, is the sole purpose that applies in this case. And in this case, a young man was killed because Officer Potter was reckless. There rightfully should be some accountability. Sentencing guidelines are just that. They are guidelines that inform a judge regarding sentencing for various crimes. They are not set in stone. The court has the discretion to depart from guidelines depending on the particular facts of a case. A downward durational departure is justified if a crime is less onerous than typical. Put another way, if the conduct is significantly less serious than that typically involved in the commission of the crime, sentencing below the guidelines is justified. I find the facts and circumstances here justify a downward departure from the guidelines. First, Officer Potter's conduct was significantly less serious than your typical manslaughter case. The misdemeanor predicate for the manslaughter count was reckless handling or use of a firearm. Here, everybody agrees, and the evidence is undisputed, that Officer Potter never intended to use her firearm. She mistakenly drew her firearm at all times, intending to use her taser. There were police officers and experts who testified that the use of her taser was reasonable and appropriate under the circumstances presented for officer safety reasons. The fact she never intended to draw her firearm makes this case less serious than other cases. Second, the scene was chaotic, tense, and rapidly evolving. Officer Potter was required to make a split-second judgment. That constitutes a mitigating circumstance. Finally, unlike other manslaughter 1 cases, Officer Potter's actions were not driven by personal animosity toward Daunte Wright. Instead, she was acting in the line of duty in effectuating a lawful arrest. This case is highly unusual. The other officer cases tried in this court are distinguishable. This is not a cop found guilty of murder for using his knee to pin down a person for 9.5 minutes as he gasped for air. This is not a cop found guilty of manslaughter for intentionally drawing his firearm and shooting across his partner and killing an unarmed woman who approached his squad. This is a cop who made a tragic mistake. She drew her firearm thinking it was a taser and ended up killing a young man. Ms. Potter, will you please rise? Given all these considerations, and having carefully considered the comments of the family of both Daunte Wright and the comments of Kimberly Potter, as well as the arguments of counsel, it is the sentence and judgment of this court that you shall be committed to the custody of the Commissioner of Corrections for a period of 24 months. You shall serve 2/3 of that time, or 16 months in prison, and 1/3 on supervised release, assuming no disciplinary offenses or conditional release violations. You have credit for 58 days already served. Restitution will be reserved. There'll be a fine of $1,000 and a surcharge of $78 to be taken out of prison wages or due within 180 days. You must provide a DNA sample. You may not use or possess any firearms, ammunition, or explosives. You have the right to appeal the conviction and sentence. If you are unable to pay the cost of an appeal, you may apply for leave to appeal at state expense by contacting the state public defender. You may be seated, Ms. Potter. I'd like to make a few parting comments. I recognize there will be those who disagree with this sentence, that I granted a significant downward departure does not in any way diminish Daunte Wright's life. His life mattered. And to those who disagree and feel a longer prison sentence is appropriate, as difficult as it may be, please try to empathize with Ms. Potter's situation. As President Barack Obama once said, learning to stand in somebody else's shoes, to see through their eyes, that's how peace begins. And it's up to you to make that happen. Empathy is a quality of character that can change the world. Officer Kimberly Potter was trying to do the right thing. Of all the jobs in public service, police officers have the most difficult one. They must make snap decisions under tense, evolving, and ever-changing circumstances. They risk their lives every single day in public service. Officer Potter made a mistake that ended tragically. She never intended to hurt anyone. Her conduct cries out for a sentence significantly below the guidelines. Okay, thank you. Thank you, Kelly.